The one that is always blowing off of you now. But no,
Don't worry, I'm not biased. I've been subjected to them, or you know what I mean?
Right,
Like I'm so new, That's just normal, right?
used to it, right, yeah.
Yeah.
No. Oh, you
Thank
got
you for your
it.
constant
Yeah, I
stream
don't
of
know what you
info.
want the screen to look like. Maybe just blow up the Zoom portion, like with that green arrow thing. Just kind of. Yeah.
Cool. It's auto tracking us right now, and love it.
Lovely.
I need to work on this double chin. I recently lost like 40 pounds and I put it all back. Killing myself. I'm kicking myself. Anyway. Yeah. Good stuff. 17-day fast. Yeah, a little crash diet.
17.
Yeah.
Would you have any sort of liquids or? Okay.
Yeah. No, I didn't go, I mean, I tried to go the Moses route and like do 40 days of nothing.
And your body would.
I spent, what was it? I spent 10 days with protein shakes and tomato juice and whatever juices I wanted. And then it went 17 days of water only. And then I did another 10 days back on the protein shake. So it was about 40 days, but.
Wait, what is that? You have 40 days without food? Sorry, I popped in on this.
Little fast, little fast.
Dang. Was that hard? Or was
Just
it
entertainment for Sandy. Hi, Sandy. It's good having lunch with you. I like eating food. I proved this. You know.
Good to see you, Chip.
When did you do this?
This was August.
Your body went like full starvation mode?
Sure. I mean,
Yeah.
I eased myself into not eating everything, and now I've eaten it all back on. Oh my God.
Oh, stop it.
I'm looking at myself on camera. No, I've been feeling it this few days. Anyway, these are auto recording off.
How are you doing?
Good.
Good. All right, I may want to turn off one more of these copies. All right, now, we can wait until anyone else.
I'm really impressed by this camera, actually.
It's not really clear. It's called the owl, I think.
I'm getting into doing event photography and event cinematography, and actually I've recorded some multi-camera setup meetings lately, and that might be a game changer.
That is some smart technology.
All right, y'all, well, we can go ahead and get
Okay.
started, and if anyone wants to join in, on Zoom, we'll let them pop in. We've got Sandy. Hello, Sandy, hope you had a good weekend. And Sandy, I do have a settlement statement here. I'm gonna run through a little bit, but, I know you had a couple closings with me, so I know we, you know the gist of it, but I am gonna cover just a couple of things if you wanna just listen in on that. And for y'all, I know Chip, I met you, and what was your name?
Betty?
Very
Betty.
very nice to meet you. And my name is Amy Smading. I'm an attorney with McMichael Gray. Emily Raven is the agent service representative here in the office. Our office is right outside the door right here. So y'all feel free to pop by anytime with questions. But let's go ahead and dive in. So the first thing that I do want to let y'all know for closings is whenever you go under contract, make sure you send everything that you've got to the closing attorney, whether that's us, whether that's someone else. Don't assume that the other side is gonna send everything. Go ahead and send it. We'd rather have it sent multiple times than be missing any of the exhibits, amendments, any of that kind of stuff. Go ahead and send us everything you've got. If you're closing with us, the best email is gonna be KWCN, so Keller Williams, Chattahoochee North, @mmg.law. And also send it to me and Emily will send it in, but just wanted to give y'all that heads up. We do have a group email where it goes to our whole team. So keep that in mind. The other thing that you're gonna wanna have right away when you go under contract, go ahead and send all of your contact information for your client, whether you're on the buyer side, you're on the seller side, go ahead and send an email and a phone number. Reason being is that the next step, no matter where you close, they're gonna ask you for that information so that they can send out the information forms. For us, for seller, that information form is crucial, because if they have a mortgage payoff, they're gonna have to complete that information so we can get a payoff order. If they have an HOA, they're gonna need to give us that information so we can get an HOA letter ordered. All that kind of stuff, that's gonna be listed on that information form. For your sellers, we have had a lot of questions lately regarding power of attorney, especially for sellers. I have doors that we don't have parking, we're gonna go play with the puppy. But we have, this weekend, actually, I got a couple text messages about power of attorney. So with a power of attorney, do y'all know the type of power of attorney that you need in order for either a buyer to purchase or a seller to sell property in Georgia? So it's called a specific power of attorney. And that allows them the specific power to sell that specific property or to purchase that specific property. So if you have a client that says, I already have a power of attorney in place, that immediately needs to be a, hold on, what kind of power of attorney is it? If it's a durable power of attorney, if it's general power of attorney, if it's a financial power of attorney. Those are typically powers of attorney documents that are created by an estate planning attorney for purposes once they're either incapacitated or unable to do things for themselves. It's not typically the type of a power of attorney that's needed for real estate purposes. So keep that in mind because that does come up all the time. The reason being behind that, if they have one set up for estate planning purposes, there's not typically a provision in there that has the notary and witness with your two requirements when you're signing a deed. Those are typically not involved on the power of attorney that they would get from the estate planning attorney. So once we get through the title clearance and that portion of what we're doing, the underwriter is gonna ask us, why can't they do another power of attorney? What's the reason? Because are they not able to, they're out of town, whatever it may be. But if they don't have a good enough reason, the underwriter is gonna say, nope, we gotta get another power of attorney executed. So when you hear that, go ahead and let them know, great that you have this, but it's probably not gonna work for real estate purposes. So just keep that in mind for that. And then also, if you are the listing agent and you're gonna have the seller as your client, go ahead and ask them for any kind of documents that they have. If they have their owner's title insurance policy from when they purchased the property, you're gonna wanna go ahead and obtain that. If they have survey or whatever documents they have, go ahead and get that together. When you're also, as the listing agent, what you're gonna wanna do is get a copy of the deed, whether that's you get us to help you pull it or you pull it yourself from the public records. Go ahead and make sure who is on title to the property. We had another one not too long ago, where the listing agreement had 2 sellers on it. There's actually 3 on title. So they didn't get that third person to sign because they had added their adult child to the title, not realizing that adult child now had to sign as the seller of the property.
Where we can find those information for the title information?
Yeah, so you would want to actually pull the deed for whatever county that the property is located in. Emily and I are happy to pull that for you, but what you would do in order to pull the deed is go to the county where the property is located, the tax assessor's website, put in the property address, and it'll tell you the last known transfer. And so that way it'll tell you the book and the page number, and you can pull the deed from the Georgia clerk's website. And I can actually I'll probably do a class on that, coming up on how to pull the different deeds, because it can be a little bit tricky. Once you get the hang of it, you'll know what to do. It's a little bit trickier with like land. If it's like vacant land, that can be a little bit trickier, but for typically your normal resale house, pretty straightforward. But yeah, so you'll want to do that, see who is listed on the title of the property, and that's going to be your sellers. So that's another thing. If you've got, let's say it's Emily and I on title, and then you only get one of us to sign the documents, you're going to immediately say, where, if it was just me signing, you'd say, where's Emily? Why is she not signing? Is she alive still? Is she out of town? What is the reason she's not here? Because that's going to be, of course, a flag for you if you only have one person, but you see 2 people in the title. That's got to be your next question. What's, is there a marriage situation? Is there a divorce situation? A death? Look into that, because if there's a death, you're of course going to want to look at how they held title to the property, whether it's joint tenancy or tenants in common. you're gonna wanna start looking at that. Do they have a death certificate? And all that kind of stuff. And actually, speaking of that, can one of y'all tell me the difference between tenants in common and joint tenants? One of you.
It's, with one, your ownership passes away with you, and with the other, the ownership is transferred to the next heir, or, what is it, their spouse, or, you know, any number of things.
Yep.
Which, is it joint tenants where your tenancy does not survive? Is that right?
Joint tenants with right to survivorship, it's gotta have those crucial words. But what that is if you and I own property as joint tenants with right to survivorship, if
Yeah.
I die, my portion goes to you fully, and you
Okay.
don't have to go through.
I get the vacation home.
So yeah, if that's with joint tenants, if we held it as tenants in common and I died, you would then own your 50%, and then my heirs would own 50%.
This is not recommended for marriage,
So with marriage, typically it would be joint tenants with right to survivorship, because the thought behind that is that that surviving spouse doesn't have to do anything with the property at that time. Until they sell the property, and the only thing that they would need to do would be to have the death certificate, and at that point, you would sign an affidavit at closing, and you would say, yes, Amy died on XYZ date, my husband would then own it fully. You have to provide my death certificate, and you would sign an affidavit saying, we own the property as joint tenant, Amy passed away on XYZ date, and now I'm the sole owner of the property. That's reported whenever he would sell the property to whoever, but those are the two things, where if we held as tenants in common and I died, you would have to actually go through the process of going through probate. And the probate can take months and months and months, so, it's definitely for marriage, it's easier to have joint tenants.
Isn't it just easier if the wife just owns the house?
You still, I always recommend having both on the title, but at that point, it's really up to whatever people's situation is. But tenants in common can come in handy if it's like, I own property with my brother, or you own property with a friend, or at that point, you could also do LLCs and all that. But it really just depends on who they're adding and what their situation is. But I did wanna make sure y'all knew the difference between the joint tenants and then the tenants in common, cause that will, of course, make a big deal, or make a big difference, depending on what your situation is for your sellers and clients.
I have a question, because this situation happened because, the person buy the house, right? But the loan is by his name, okay? But his mom is like kind of business, family business to buy the house and sell later and get money all of them, right? And there his parent asking to do extra letter to say it's like I guess, to say he cannot sell the house, he cannot do anything without their permission. That is something,
He sold his house to the family business, and
no, he buy the house, right? When he buy the house, his parent asking to do like deed letter, like agreements. The agreement, like he cannot sell the house, the loan is in his name,
So on title, is it just him or?
only,
LLC.
only his name.
I would be very curious to see what kind of agreement that they have that's precluding them from being able to sell the property, because if it's just him on the title,
he should be able to.
he.
It means the agreement is no, it means like it's not gonna work.
I won't say that because I haven't looked at it, but I would be very curious to see what kind of agreement that is.
Why would the?
Yeah, I would wanna look at, and I don't wanna give a hard yes or hard no, but that would be a first. If it's precluding him from being able to sell the property based on something that's not on title, that would be different. Now, I wonder if maybe they put some type of either lien or mortgage on the property or something where they have to get paid first. But I would be very curious, because that's not a typical situation. So on that one, you wanna dive in a little further.
Yeah, this guy, he called me, he wanna sell the house, but he told me about that. And I tell him, okay, just talk to your parent, tell them you wanna sell the house, and they no, because they no agree with me to sell the house right now.
So
And then, he doesn't know. I guess you need to look the lawyer and see what the agreement says.
That's exactly right. So that would be the next steps for that particular situation. Get a copy of that agreement, give it to an attorney, have the attorney run through it and then see what his options are. Yeah, I would be very curious. Come chat with me. I wanna know more about that one. But yeah, that's not your typical situation, but yeah, I think that's
Yeah, it
something.
was like, I asked him, why you didn't put your parents on the title,
Mhm.
right? Easy. Because one of them doesn't have paper, no? He doesn't have paper. His mom has it, but father, he's a state father, he's that,
Yeah,
the state that doesn't have it. That's why I said, okay, just put your mom on the title. Your mom has it, yes, my mom has it, okay, just put my mom. No, but she won my state father in somewhere and they, buy the house, the
Yeah.
person buy the house. And now he wanna sell her, but he had no
see, and
conflict.
just to make matters a little bit more confusing with that, they may also have an agreement that's attempting to prevent him to be able to sell the property, but it may not even be enforceable. Depending on what they've got in that, it may not be enforceable. So I would definitely have him get the copy of that agreement.
Maybe ask him why.
I'm not telling him to start a war with his family, but
We need
he
like
may,
3 first.
yeah, it may not be
It was
enforceable,
like,
but
Celeste say something weird, I don't know.
Yeah.
Because, wow, what did she do to you,
yeah, that's an interesting, interesting setup that they've got, but also kind of on that note, do you know if there's a loan on that property? Or if it's, does he own it without a mortgage on the property?
Yes, on the his name,
It's on, but does he have a mortgage, do you know?
no.
No mortgage, okay. So what I was getting at with that is that when you were talking about adding his mom to title, whenever there's a mortgage that's on the property, you actually cannot add a parent's one to title. The only people that are allowed under the due on sale clause exceptions are spouse or adult child.
Oh, he cannot.
So if he has a mortgage, so that's the catch, if it's free and clear, he owns it, he paid cash for it, you can add whoever he wants to title, and it doesn't matter. But if there's a mortgage on the property,
I think he has a mortgage.
so if he has a mortgage, he actually would not have been able to add his mom anyway. Because that would trigger that due on sale clause, the lender could in theory call the loan due in full. And then-
Probably that's right. He might be asked when they do the house process, maybe, that's why maybe they decide to do that agreement.
Potentially, yeah, but yeah, so if there's a mortgage, it can only be a spouse or an adult child. There's also provisions for a trust, but it has to already be in creation, the beneficiary, also the settler has to also be a beneficiary. There's a few other terms, but the ones to remember is spouse or an adult child are the only exception that you can add on the title. Siblings are no, parents are no, anything like that. Fiancés are a no, and that's what we get probably the most of at closing, is that they'll bring their fiance and they'll say, hey, I want her to have them added to title. And
Marry her on paper.
yeah, we need the marriage
Not bad.
certificate, and then you can do it.
Go to the courthouse.
Exactly, yeah, you can't just have them right now, you gotta wait a little bit longer. Let's see, so we've gone through a lot of this, for earnest money, I'm sure you'll probably already know this, if you're gonna have the closing attorney hold the earnest money, it also needs to be a wire transfer. So they can't drop off a check or anything like that, it needs to be a wire transfer if the closing attorney is holding it. If it's Keller Williams holding it, I believe they will still accept a check. I know they also have an earnest. They may have talked about that with y'all, it's kind of like an ACH transfer, Keller Williams will allow that as well. Just keep
Oh,
that in
yeah.
mind. Yeah, for us, it's gotta be a wire transfer. Another couple other documents that I wanna talk about, is gonna be for there's a lot on the seller side. But for seller, y'all probably already know this, if they are not a resident of Georgia, or if it was not their primary residence for the last couple of years, there will likely be a withholding for them. Do y'all know what that percentage is?
No.
So it would be 3% of the sales price. If they're not a resident of Georgia, or if it was not their primary residence for the last 2 to 5 years. Or the third option that they could do, and we'll walk them through this, would be to do the, capital gains calculation, so they would actually tell us what they bought it for, or excuse me, what they're selling it for, what they bought it for, deduct that out, get your cost basis, take out any other deductions, any kind of improvements they've done on the property, any depreciation, all that kind of stuff. And typically at that point, you don't want to assist them on that. You want to tell them, go talk to your accountant, go talk to your tax advisor. That's not something you want to give them advice on. And honestly, that's not something that we can give them advice on either, but we will tell them these are the numbers that you're gonna need. Go find them out with your accountant or your tax advisor, and then they will calculate that out. But those are the things to keep in mind. If you hear it's an investment property, but they're not a resident of Georgia, you want to initially pass them contact information for whatever attorney that you're closing with so that we can walk through that with them. Same thing if they are not a US citizen. At that point, FERPTA would come into play, and do y'all know how much the FERPTA percentage is?
3%?
Nope.
More or less,
It is more.
more,
So FERPTA is
15.
there you go, Sandy. But yeah, it is 15%. There are also some exceptions for that. Some of them off the top of my head is if the sales price is 300,000 or less. And if the buyer is purchasing it as their primary residence. These are all the things you don't have to remember off the top of your head, but just kind of keep them in the, like, if you know they're not a US citizen, that's immediately gonna be your, hey, let me talk to Amy about FERPTA. Let me see what we've got here. Or let me let my client know there may be something, but let's check with the attorney. So those are the kind of things you wanna think, okay, not a Georgia resident, let me chat with Amy. Oh, not a US citizen, let me chat with one of the attorneys and see what we've got going here. But yes, for FERPTA, it's 15% unless it's 300,000 or less, buyers purchasing as the primary. But just keep those in mind if y'all have any of your sellers that have that. Another thing for sellers mainly with buyers, of course, the lender, if they're purchasing as an LLC or as a trust, anything like that, the lender's gonna have their certain requirements and documents that they would provide over to them anyway. They may or may not allow them to purchase as an LLC, it just depends on a lot of different things. But as the seller side, they may already own it in their LLC or in a trust. So that's gonna be another thing when y'all are initially getting your appointments going with the client and you're signing even your listing agreement, go ahead and tell them to start grabbing those documents. Because we're gonna need to see signing authority for whatever entity that they're closing in, we'll need to see those documents. For an LLC, it's typically gonna be an operating agreement. And that operating agreement will tell us if it's member managed or if it's manager managed. And so it's gotta be one of those two things for the LLC. You can actually, y'all know where to find the LLC documents to make sure that they're active with the state of Georgia.
Secretary of State's website.
Exactly. Yeah, so you can actually Google Georgia Secretary of State, pull it up, search the LLC, and you can make sure that it's already active. And on that website is where you'll see usually their certificate of, or articles of organization. And that's not really what we need. So that's a lot of times people will send that over to us and that's helpful because we're able to see that it's active. But that's not gonna typically tell you who has authority to sign for the LLC. It'll sometimes tell you who the registered agent is. And it sometimes will say member or manager, but it won't actually give us all the information that we need. A lot of people will go ahead and get an LLC set up and they don't actually have the articles of organization that we need. Or the operating agreement, excuse me. So if they don't have that, also that's another thing that you'll wanna let us know because we'll draft a resolution and that'll have all the members or all the managers sign it and give one person typically authority to sign on behalf of the LLC. One-page document takes just a couple minutes to draft it, but that's something that we like to have set up prior to closing.
Does that need all parties involved in the same room at the same time?
All parties or all of the members or managers? Typically, yes, but like, let's say that there's 4 of them, we don't require a notary on that, so we also have been able to send it out via DocuSign. But we would need everybody's contact information in order for them to tell us who they agree on to have signed on behalf of the LLC, but that's really the only catch, they don't have to come in and sign it or anything.
It's a nice short way.
Yeah.
Okay.
Yeah.
It's convenient.
Yeah, definitely makes it more convenient. And then also another thing to keep in mind, we kind of talked about power of attorneys earlier. For the most part, if let's say they did not have a resolution and it required multiple people to sign, to not have a power of attorney for LLC members or typically members of the trust. So at that point, you're gonna want them to either agree and we can do a resolution authorizing one person to sign, so the power of attorney is not needed. And then for a trust, typically, we'll have to make some kind of arrangements for them to sign separately if they can't all make it on the day of closing. Because at that point, you cannot get a power of attorney for someone to sign their portion for a trust. Does that make sense?
Yeah. Because power of attorney is for an individual.
It,
Trust is not an individual, it's an entity.
exactly, that's exactly right, and it would, you can't give them power to sign, same thing for, if it's an estate. You can't give someone power of attorney to sign out of your position as executor of that estate, that's not a thing. So at that point, you gotta make sure whoever is the executor of the estate is available. But at that point, you know, we can always make accommodations, people aren't gonna be out of town forever. So we just have to coordinate when they are in town,
You
or
think
whatever the
so?
case may be.
You'd think that wouldn't be out of town.
Yeah, you think so, but yeah, there's sometimes it takes a lot to get things scheduled, so. But yeah, so those are kind of some of the big things. For a marriage, another question that we've had, let's say that you have, you're representing the buyers, and they're both getting on title, and it's, the future husband and future wife, the wife is going to change her name, but hasn't done so yet. The only thing that you need to tell them is you don't have to change any of the documents for your house unless you want to. Doesn't matter that your name is now Smading instead of Blackman, because whenever they sell the property, the attorney would ask for a copy of the marriage certificate. And then at that time, we would do a formally known as language on the deed. And they would just provide that marriage certificate, provide the new ID, and you're done.
Cool.
A lot of times people think, oh, I gotta go change the title of my home. I actually had a friend of mine text me that not too long ago. Don't have to do it. Don't have to. If you do want to, you can, because otherwise it's just another fee that you pay. So I would suggest not to do it. All right, so let's see. All right, can y'all tell me some of the forms of identification that are allowed at closing? What kind of documents do we need to see?
Passport. Social security card. No, birth certificate?
This ID,
So we need a government issued picture ID. So it could be passport, driver's license, green card, anything
Voting
that's got,
card, yeah.
anything that's got your picture on it. For a secondary ID, we can absolutely take a social security card, or a birth certificate, anything like that, but we've gotta have a picture and it's gotta be also not expired. People have brought expired IDs and that is not allowed.
for, I don't know if this is below this, class, it's about, the loan. When somebody, requests for the loan, buy the house. Which is the same, ID, you say a passport, driver license,
So what are you talking about when they're applying for the loan? So yeah, typically the lender's gonna wanna see either passport or driver's license or some type of identification that has a photo on it.
okay, that's all, but it's not necessary like, okay, American passport, or you wanna see your citizen, right? Or like green card or something, but that person have a driver license.
Mhm.
I mean, it should be work, right? Or not for any loan.
That should, I would check with the lender to confirm on that, but my understanding is that any kind of ID that would work for our purposes would work for the lender as well. They may ask for additional documents, because a lot of times in order for you to get cleared on the loan side, they're gonna ask for tax information, pay stub, all that kind of stuff, but just for purely identification purposes, a passport should work.
It should.
Library card,
driver's license.
library card with a picture on it?
Not for the lender, they're gonna wanna see something a little more, but yeah, that, any of those forms of ID should
It
work.
should be
They
work.
may just ask for additional documentation, but I would check with a specific lender just to make sure you're meeting what they need. But yeah, anything that's government issued, has a picture and it's not expired. I know that sounds self-explanatory, but you would be surprised how many people show up and their ID is expired. And
I
not-
would probably need your reminder.
It's, I mean, it is, I know it's just one more thing to remember at closing, but, definitely wanna have that. Another thing for y'all is of course for commission, send over the form to us as soon as you have it. Letting us know what amounts the percentages for commission. The other thing is get over, if you have a pay close or disbursement authorization from the market center, I believe Kim is the one that signs them here. Make sure you get that over to us, because otherwise, whatever we have on the commission agreement, if we don't have that DA or that pay close, the full amount is going to the market center. So if it's anything that's gonna be paid to you directly, we've got to have that in the file. Ideally at closing, prior would be ideal, so we can have it set up, but definitely by closing. And then Sandy, I know you can't see the settlement statement, but I am gonna start running through the settlement statement with y'all. So they've got this here, and I'll kind of talk it out loud so you can hear what I'm saying too, Sandy.
Thank you.
But what we have here, so have y'all had any closing through Selena last couple months? No, okay. So have y'all seen a settlement statement before? No, okay, perfect, awesome. So what I typically, so this is the all settlement statement, used to be called the HUD, it changed in I think 2015. So you hear people talk about the HUD and you hear about them talk about the ALTA, generally the same thing, it's just a different format. So the closing attorney will send out this ALTA or settlement statement, and the lender, if there's one involved, will send out the closing disclosure to the buyer. They have that 3-day trade requirement where the buyer must receive that 3 days prior to closing. Few changes can happen, but there's a certain percentage that if it changes more than that, the lender would have to send out and redisclose. Just kind of an overview, but yeah, if you're ALTA or settlement statement, this is what we're talking about. Most attorneys, I believe, go through this, but some go through the closing disclosure first at closing. But what I like to do is go through the buyer side. So those are the right 2 columns. And then I go over the seller side at table in front of them. I just do buyer and then seller. So I'm actually going to run through this now as if we are actually at a closing. So we'll do the buyer side first. So we have for the category for financial, you'll see that first in bold. I would run through and tell them you've got your sale price of the property, it's being offset with the credits. You've got the loan amount and then a seller credit that the seller is given to offset some of their closing costs. The only other item that would typically be here would be the earnest money. So that would of course be a credit to the buyer on that side as well, because they've already paid that into either the closing attorney or the brokerage. For prorations and adjustments, this is the part where it's gonna change depending on what time of year you're closing. So if you look in this top section right here, you'll see that we have the settlement date as Valentine's Day. So this is based on a closing date of February 14th, 2023. So at that time, taxes for 2023 were not out yet. So on a settlement statement now, that would be flipped. So if you look down here, you'll see HOA dues for a debit from the buyer, so debit due from the buyer, and that was prorated from the closing date of February 14th all the way to the end of December of this year. So that's their amount that covers them for the full year. For the city and the county taxes, they're getting a credit. So they're getting a credit from the seller, and that's for the seller's portion of owning it from January 1 through February 14th. So what that means is, of course, when the tax bill comes due, which is in the fall for every county in Georgia, it's gonna be the buyer's lender, if they have a lender, and if they have an escrow account, would pay that from the escrow account, and they're already getting the credit at closing. So for the seller side, we'll flip over there real quick. You'll see that that's debited from them, but let's say hypothetically that they were closing today. If the seller had not already paid that tax bill for the full year, the seller would be getting a credit back because they've already paid the tax bill. Does that make sense? And do y'all know what the taxes are based on? So for this closing right here for February 14th, what would the taxes have been based on? Because we don't have the tax bill for 2023.
Talking village rate?
You're on the right track though. It's basically based on the prior year tax bill. For new construction, of course, that's gonna be different. They are gonna go with more the millage rate, try to get the best calculation possible. But for a already built home, they're just gonna base on the previous year's tax bill. And so with that said, for this one, if, let's say the seller, it was their primary residence and they had homestead on it, the buyer is actually going to benefit from that for that year's closing. So for the next year, unless the buyer goes ahead and applies for the homestead exemption, it would fall off of the property. So in that case, the next year would go up. So make sure you tell your client, if it's gonna be a primary residence, you gotta apply for your homestead exemption with the county, and that'll lower the property taxes from what they would normally be. But for this one, since it was a hypothetical February closing, we've got credits for the buyer side for city and for county taxes. The next section is gonna be with the lender. So we've got here, any kind of fees that we get from the lender where we're balancing the settlement statement, we just plug it straight on there. So a lot of these are the most typical things that you'll see, but we just put whatever they tell us on for the lender charges. So here we have the points, the processing fee, the underwriting fee, credit report, appraisal fee. If they paid any of these outside of closing, all that we would do is put it under the description section right here and just put paid outside of closing or POC. So we'll flip over to page 2, it's on the back side. We've got a couple different charges still here. We've got flood certification, tax service fee, VOE is verification of employment, LOE, another term, I'll probably know for letter of explanation, anything like that from the lender. For prepaid interest here, either of y'all tell me what the prepaid interest is on the lender side?
Do you mind?
So I guess that's. So prepaid interest, basically the interest for a mortgage is paid in arrears. So the date that you're closing, you're gonna pay prepaid interest for the rest of that month. And that covers you up for the interest. And so for this closing, the first payment would be on April 1st, because you're paying prepaid interest from February 14th through February 28th. So you don't pay March 1st. Your April 1st payment to the lender covers all of March's interest because it's paid in arrears. Does that make sense? So yeah, basically that's kind of your fee. If you close on July 14th, what would your first payment to the lender typically be?
Be more than, if it was July 1st.
Well, what date would it be?
To
July 14th closing.
to August 1st.
So your prepaid interest would cover up to August 1st, so your first loan payment would be
A month.
September. Yeah, so it'd be September 1. So that's kind of your cue if your client says, when's my first lender payment? Okay, what's your closing date? Oh, it's October 14th. Okay, it's gonna be December 1st. Yeah, so you can kind of remember that, covers you for the rest of the month, and then you go to the very next month. But yeah, so basically your prepaid interest, of course, if the closing was on February 28th, would be much lower. So it's gonna be basically 1 day left in the month. The next chart or the next section is other loan charges. That's gonna be typically to get the documents recorded with the county, there's $9.50 per document. That's a fee that's charged by that company. And then for Georgia, they recently changed that, I believe in the last 2 years. They used to pay for the amount of pages in a document. Now it's just a flat fee. So if you have 2 documents, a deed and a mortgage, it's $25 per document, so you have a $50 recording fee, as opposed to, oh, it's a 3-page deed and it's a 17-page, how many different pages is it? They've gotten rid of that, thank goodness. It's a whole lot easier for us to do a flat fee rather than count the number of pages. So you'll see that further on down, but I wanted to highlight that for you. So impounds is the next category, and that is actually the escrow account. So with this, you can see that the lender is gonna be holding the escrows, the homeowner's insurance, and then the property taxes for city and county. They do have an aggregate adjustment credit here. And whenever y'all see that, the lender, when they're disclosing, they have to make sure that they're disclosing the correct amount to the buyer. So they would rather overestimate than underestimate on that. So when you see that aggregate adjustment credit, that's just the amount that they've overestimated. So if you add up the 3 debits there, subtract out the aggregate adjustment credit, that's to the penny how much is starting in the client's escrow account on the day of closing. Of course, after that, each month when they're making their payments to the lender, that's gonna build up their escrow account. But if they're asking how much is in there on the day of closing, that's how you can add that up. The lender will of course also tell you all this too, but that's just another thing to keep in mind. All right, so for title charges and settlement charges, these are gonna come from McMichael and Gray or whatever closing attorney that y'all use. So you'll see here, we've got the closing protection letter. We've got the title examination fee, and closing protection letter also, is just in case there's any errors that are made. That's the coverage for the title, the underwriter title company to actually make sure that they're covered on their end. Title examination is for us to actually get that exam from the examiner, and then we review through it, make sure that there's no title issues. If there are, we would of course let y'all know. Title binder fee is gonna be any type of change that was made when we reviewed the title up to the closing date. So on the closing date, we don't get a title update that day. So that's the coverage to make sure that gap period is what we call it, that if there was any kind of things that were reported, that's the coverage for it, so that we can still proceed to closing. We've got the post-closing fee, the attorney settlement fee, owner's title insurance and lender's title insurance. So owner's title insurance, I'm sure y'all remember this from all your classes, very, very important. The owner's title insurance is technically optional, but you want to always recommend it to your clients, because if there's ever any kind of issues on the title to the property, that is their coverage. That's their coverage in the equity in their home. It is a one-time fee, and it's good for as long as they own the property. So here, they are covered up, and then whenever they sell the property, their buyer would need to obtain their own owner's policy. But it can cover anything like a previous open security deed that wasn't closed by a prior owner in the back chain of title. It could be a minor error in a legal description. It could be coverage for an estate. There was one case that I actually got subpoenaed for up in, I think it's Forsyth County. But there was an entire subdivision by a builder that we work with. And there was no issue with chain of title, but basically someone's grandfather had owned that acreage before they built the subdivision on it. And the grandson was trying to say that he had a claim to that property that was his grandfather's. He did not. It had been, the state was probated correctly.
Sounds like a Forsyth County issue.
But he was trying to say that he was due some of the money from that subdivision being built. So everyone in the subdivision who purchased owner's title insurance was able to have an attorney represent them and fight off that claim. Anyone who did not have owner's title insurance was paying a lot of money to try to fight that off, even though it was not a valid claim. You still have to fight that off. So that's one example that I like to use just because I was involved with it for owner's title insurance, and it being such a good one-time investment so that you don't have to deal with anything like that, writing off claims on your property.
The title examination, that's optional too, or that's has to?
Title examination has to be done. That's for us to actually pull it, review it, and make sure that there's no issues. So you have to have that done just to make sure that we can validly transfer to the buyer. The part that's optional is that owner's title insurance.
You guys do that yourselves and you don't outsource it to like a,
So we have a third-party title examiner that pulls all the documents for us, but no, it'll be for any of our files. I actually review it or another one of the attorneys. But yeah, we do not outsource the actual review of it.
always
Just
curious how that worked. I had an aunt down in, East Point, Florida. That I believe is probably a third party examiner for those.
yeah, we have people pull it for us, but then we actually review it.
Cool.
Yeah, I like to have my eyes on all of our titles for any of our, stuff here. Lender's title insurance is not optional if there's a loan. Of course, if it's a cash, that would not be there anyway. But the lender is gonna always require lender's title insurance, but owner is the option there. And we'll flip to page 3. And I've got a question for y'all, and Sandy, you can join in on this one. So it has the reporting fees to the county of $50. So how many documents here are being recorded? Anybody? Emily, join in too. So for the reporting fees here of $50, how many documents are being recorded?
Oh, reported fees and transfer.
Great, I'll go ahead, remember what I was telling y'all about the number of pages and how they did away with that?
It's just for 2 documents, right?
Exactly, yep, perfect. So that's your key, is that, okay, $50, I know there's 2 documents that are being recorded. Where before, it could have been $82, and you'd have to say, all right, $10 for the first page, $1 per additional page after that, that's how they used to calculate it. And let me tell y'all, it was a pain. You throw in one additional exhibit A in there, and it throws your whole recording fees off, so big fan of that change. That's why I was harping on that earlier, I knew I was gonna ask y'all that question. The next one down, you'll see city, county, state tax stamps. What that is the intangible tax. So that actually goes to the county and it's based on the loan amount. It's like 50 cents per every $500, and then you times it by something. There's a calculation, our system does it automatically, we plug in the loan amount and it figures it out for us. But that is based purely on the loan amount. TRMA is the Georgia Loan Act fee, so anytime there's a lender, you're gonna see that additional $10 charge. State tax and stamps are calculated based on the sales price. So you can actually easily see here, sale price, if you look at page 1 was 600,000, and the transfer tax is $600.
That's just $1 for every $1,000.
That's exactly right. And so if y'all are ever pulling another trick here, if you're ever pulling a deed for your client, and you see in the top right-hand corner, you see a state tax or stamp, or the transfer tax, you see it as $965 on the actual face of the document, and they say, I don't remember what I sold it for. $965,000. So you just do that calculation, just looking at the face of the document, you don't have to do anything else. And that's just a nice trick to have in your back pocket if they say, I can't remember, just look at the face of the deed and you can tell them. We'll jump down to miscellaneous here. So you'll see you have the homeowner's insurance premium. That's for the first full year. So you'll see here they have $2,500 for the premium. And then if you remember on the escrows or the impounds category, there's another section. And that's actually a pretty common question that I get at closing. Why are there 2 line items? It's because you're paying for the full premium for the full first year. You pay that up front, and then you also get it started in your escrows. So that's why there's 2 separate line items there. For HOA, you have the initiation fee on the buyer side, you have the transfer fee on the buyer side, and then you'll see down at the bottoms here, the top 2 lines there for debits and credits are just telling you what the full amount is for all those items we just looked at. That which you subtract out the 2, that second number is the cash inflows. For HOA though, I don't think the document here, but for the community association disclosure, are y'all familiar with that form? No, so just keep in mind for that one, don't have it here, but there is a section on there for disclosing any kind of initiation fees, transfer fees, all of that. And if the seller does not disclose those, you do know that the seller then would be responsible for paying them. Are y'all aware? Y'all remember that? So just keep that in mind. If you're representing a seller, make sure that they contact their HOA, find out what those initiation fees are, transfer fees are, that you can put those onto that community association disclosure. Because if it's not disclosed, it's the responsibility of the seller. If it is disclosed, it's the responsibility of the buyer. You definitely don't want to get your client in a situation where it's not disclosed and now they're paying for something that they normally wouldn't have had to pay.
Can't ignore it.
Yep.
Can't ignore
Same thing on that same form for like an assessment or anything like that. Just make sure you tell them, reach out to your HOA directly. All right, so we'll flip back to page 1 on the settlement statement. And now we're gonna go over the left 2 columns, and that's the seller's numbers. So we've got there for financial, they have the credit back now for the sale price of the property. They have the debit, so it's due from them for the seller credit. For prorations and adjustments, and again, you're just basing this on the date that you're closing. So for HOA dues, they're getting a credit back for the rest of the year that they don't own the property. And then for city and county taxes, it's a debit because the tax bill is not out in February. So that'll be the amounts due from them prorated based on the tax bill from the year prior. Yeah. All right, and then we'll flip over that page. You've got at the very bottom of page 2 down there, we've got the listing agent commission. And then we've got on
Pay
page
up.
3, the selling agent commission.
Gotta pay up.
And then we've got just a couple more on the seller side. We've got the payoff. We have the payoff for the first mortgage. And then we have the payoff for the second, which will take the HELOC. And for HELOC, that's the home equity line of credit. With that, they'll typically sign at closing it's called the blocking letters, but it's basically them signing, acknowledging that they're not gonna make any additional draws on it. There haven't been any additional draws in the last 30 days, anything like that, to where we know that the payoff that we received from that lender is accurate. They're signing that at closing, acknowledging they haven't taken any additional draws or done anything.
Draws, do you mean like a reverse mortgage or?
No, so a lot of times with the HELOC, it may be for like construction, so they may
Oh.
have taken out like the $100,000 HELOC, but never actually
Use.
borrowed any money against it. But it'll still, there will typically still be a fee to close it out, whether it's like $100, or I think we've had one recently for $500. So they never did a draw on it, but they still have to close it out at closing.
And it should be paid off.
Yeah, they've got to pay off whatever amount they did borrow from it, or
The
they,
property.
yes, exactly, got, that can't carry over or anything like that. And then for miscellaneous, we've got just a couple more, we've got home warranty, we've got the HOA letter, and that's actually, there's a fee to order the HOA letter. The HOA will tell us what that fee is, sometimes it's paid up front and we get reimbursed at closing. Other times they allow charging on the settlement statement, that's the most ideal way to do it. We don't have to deal with any reimbursement.
The second one on your house,
Yeah,
HOA,
yeah,
they cannot do anything.
yeah, that, they definitely wanna make sure they got other fees and monies before you can sell it. Or at the time that you're selling it. But with this one, y'all will see the totals for debits and credits. You've got your total to the seller, that's the total proceeds down here. Now, I do want y'all to see on this one, on page 1, it's got the seller as John Smith as executor of the estate of Mary Smith. So for the proceeds, who would have to be the account holder?
John Smith. Oh, the account holder is Barry Smith. Okay.
Exactly, yep, that's correct, Sandy too. But yes, so make sure that, again, if you are the listing agent, if that's your client, make sure that they have either they're okay to accept a check made out to the estate of Mary Smith, or if they're expecting a wire transfer, they need the wire instructions and the account holder has to be the estate of Mary Smith. They cannot be John Smith here, because he is not entitled to that, it's the estate. And same thing if you saw an LLC, they either need to have the wire instructions for an LLC account or they can take a check for that. Y'all, any questions on the settlement statement or any of the numbers? Or any of the
It's a
topics?
good example. It's a good example.
Good. Oh, you're welcome.
Okay, why'd you pick Valentine's Day?
So we actually did a class back around that time, and I think we just kind of updated it. But also to make it start to stick out in your mind, maybe.
We love McMichael and Gray.
Yes, there we go, that should be the title of one of our
Yeah,
things.
there we go.
Emily, write that down for next month.
Yeah, that's a good one.
Fall in love with closing the make my look great. Like this. Well, if y'all don't have any questions, we'll end just a little bit early, but if y'all do have questions, I'm here for the rest of the day, so.
Stick around and chat. Yeah, great class. Thank
Thank
you.
you. Sandy, do you have any questions? We're gonna go ahead and wrap it up.
Thanks, Amy.
Thank you. Y'all have questions?
No, this is good exposure that I needed. Annie, how do you feel?
And then,
We all keep this for reference, but just really the biggest thing for the settlement statement, so a lot of this stuff is really, really standard. The biggest thing is gonna be the proration amount and then for taxes and HOA. So it really just depends on the time of year, that's the catch that you want to look at. And then, yeah, I'm just quick side and development. I can help you. So for the rest of this year, you're covered, but starting January 1, if you're closing on December 31, one on January 1, everything is gonna be swapped the very next day. This is the purchase revenue year. But that's really a catch. I always have to catch myself talking about taxes that in the beginning of the year.
It was almost upon us.
I know. Somehow. Okay,
I do a little tax on the side.
okay. So right when I was talking about all the cost basic stuff, you're probably knowing all that.
Taxes, I do homeowners association tax